Thank you, Chair Schroer and committee members, for welcoming this army of survivors and advocates today. This is a historic hearing and so needed. I'm Elizabeth Phillips from Dallas, Texas, and a very reluctant expert on both of these bills. A special thank you to Senator Hudson for authoring SB 590 to prohibit the misuse of NDAs against child sexual abuse and trafficking victims. Thank you also for naming it Trey's Law, after my late brother, Trey Carlock. He was silenced to his grave by Kanakuk Ministries based in Taney County, the greater Branson area. The action you're taking here honors Trey and the countless survivors of child sexual abuse like him who didn't survive. I am also here to testify in favor of SB 589, which would eliminate Missouri's civil statute of limitations for child sexual abuse cases against institutions like Kanakuk, a statute this state has not modified since 1939. Trey's story speaks to both bills. They are intertwined, as my testimony and others here today will explain. My brother Trey endured a decade of grooming and sexual abuse by popular Kanakuk director Pete Newman. He's now in prison here in Jefferson City for 2 life terms plus 30 years. This was followed by a re-traumatizing civil litigation process that ended with a restrictive NDA. Then, in 2019, Trey's tragic suicide. Now that I've caught my breath, I'm trying to be his voice. Having a front row seat to my brother's suffering and death, I often say that Trey's journey of injustice had many layers and multiple perpetrators. First and foremost, I blame serial sex offender Pete Newman, with 57 known victims at the time of his sentencing in 2010, and estimates that his true victim count is in the hundreds or even thousands. Next, we have to look at Kanakuk, the institution. Since launching factsaboutkanakuk.com in 2021, our survivor community has received hundreds of tips with allegations against more than 65 unique perpetrators associated with Kanakuk, with claims dating from 1958 to today. Joe White, who bought the camp from his parents in the 1970s and runs it to this day, promoted directors like Pete Newman, despite known sexual misconduct with children. Kanakuk must be held accountable for not implementing proper policies, for not firing Pete Newman after parents raised repeated red flags, for failure to consistently report his patterns of nudity with children to the authorities, and for lying to victims and everyone for decades. Instead, they are about to celebrate their centennial summer as they double down on their cover-up to preserve brand reputation. What helps them do that? NDAs. I have actually learned more about the extent of my brother's abuse and his death than I knew in his life due to the NDA Kanakuk put him under. Trey told a therapist, "They will always control me and I'll never be free," before he died by suicide at the age of 28. He called his settlement dollars blood money because taking that money in exchange for an NDA felt like a bribe. He needed those dollars for a lifetime of care, but it came at the cost of his voice and freedom. Trey hesitated even to tell his story in confidential settings like AA, for fear that Kanakuk would come after him again like they did by federally sanctioning an earlier John Doe. In 2021, survivors and their families coalesced around a petition asking Kanakuk to release victims from their NDAs, which quickly garnered around 30,000 signatures. Kanakuk's response? First, they declared they don't use NDAs. Then they admitted they do use NDAs, but only at the request of the plaintiffs. Another lie. Now they say they do use NDAs and they support survivors coming forward. However, their insurance companies may come after you if you disclose settlement terms. So we're not going to give Kanakuk any more chances to do the right thing. We're going to have to change the law. A lot of truth dies with people because of NDAs, and like a short statute of limitations on childhood sex crimes that only protects bad actors, which is contrary to public interest. To me, that is the point of Trey's Law and this hearing today: public safety, protecting children. My brother was forced by the state to file his civil lawsuit against Kanakuk before he was ready, in his early 20s. And opposing counsel's gaslighting and depositions eventually led him to a psychotic break. It's no exaggeration for me to claim that these issues are a matter of life and death. When you've survived a childhood crime, you should have the freedom to decide if and when you want to seek justice through the civil courts. Victims should have full control of their own narratives and the pace of their healing journey. Not an NDA and not a law in Missouri from the Prohibition era. For context, over 33 U.S. states and territories, including your neighbor Arkansas, have passed revival legislation for civil child sexual abuse cases because the argument is simple. Let victims of childhood crimes have access to civil courts, and then your civil courts will uncover hidden predators and the institutions that harbor them. The criminal justice system has its limits, but civil action can also lead to criminal accountability, which is what I think people who harm kids should face. Survivors have flown in from all over the country to testify, and you'll notice a pattern. The majority of child sexual abuse and trafficking victims do not disclose their abuse until much later in life. As Senator Hudson mentioned, it takes an average of 20 years for victims of child sexual abuse to come forward for the first time, if they ever do at all. You'll also learn that Missouri's draconian statute of limitations for both institutions and individual perpetrators is behind the rest of the country. Basically, if you're going to get raped in America, don't do it in Missouri. Your antiquated laws here attract child predators and organizations that have something to hide. We're ringing the alarm. It's also confusing to victims that you can sue your perpetrator up until the age of 31, but the institution responsible for your abuse and covering it up is only liable until you turn 26. This inconsistency in Missouri statute does not track with other states, and my guess is that the institutional component of the current statute has been driven by insurance and other lobbying groups more concerned about losing money than protecting life. I have a statement we can share with the committee by the largest insurer of YMCAs in the country, Redwood's Insurance Group, which stands with child sexual abuse survivors to pass bills like SB 589 all over the country. This call to action is also available on their website, along with an invitation for fellow insurers to join the good side of this fight. Redwoods even offers consulting services to peer companies that are confused about this problem and its solutions. The two bills Senator Hudson is presenting you today address gaps in Missouri's law that fail kids, and therefore all of us. Only you, as lawmakers, can prevent a story like Trey's, whether for Missourian kids or for those that come here for tourism, school, or recreation. There are Kanakuk victims from Hawaii to Haiti, New York to China, and all over the U.S. Yet this is my third session testifying before the Missouri legislature without anything passing the Senate or General Assembly. This is the first time a Senate committee has given these bills and the voices behind them the attention they deserve. So I'm here again to ask you to please remember Trey. I'm asking this legislature to pass Trey's law as an urgent matter of public safety and to give victims their voices back. And I'm also humbly pleading with you to not stop there. Please address the civil statute of limitations in Missouri for these survivors, so future victims aren't put on a clock they never even knew was ticking. Senate Bills 589 and 590, along with SJR 51, must pass this session to make progress on child protection and repair past injustices. Thank you, and with that, I'm prepared to take questions.
Thank you for your hard work on this and the strength needed to speak for your brother. Senator Brown.
I don't know if this was stated and I missed it. How long ago was it when you lost your brother?
He died in August 2019, almost 6 years ago.
Well, I know that just to come here and share your story, it takes a tremendous amount of strength and resilience. And I wanted to thank you for coming here and sharing that. Like I stated to a previous witness, just these personal stories, they are about the most impactful thing that could be brought before us. And I think that you sharing your story, I think, it definitely, tugs at my heartstrings, and I'm sure I could speak for many other people up here, so thank you.
Thank you, Senator. It comes at a high cost.
Senator May.
Yeah, I want to thank you, and I'm sorry about your brother, for sharing and all of you coming to tell your testimony, and I hope that we can do something and get it across the finish line, because it's just difficult when people have been victimized and when you're forcing them to tell that when they're still vulnerable and haven't gotten to a place of strength is very hard. So I appreciate it. I appreciate the senator for filing this bill. Thank you.
Thank you, Senator.
Real briefly, this could come up from another expert. Do you have any statistics on how often kids are victimized, especially those that are going to these camps?
The latest research nationally shows that 1 in 8 American children will be sexually abused before their 18th birthday. It's 1 in 5 if you include online abuse. I know the statistic in Texas where I live is 1 in 6. I don't think Missouri has prevalence data that's updated, but there may be subject matter experts behind me who can be more specific.
Thank you. Any further questions? Seeing none.
Chairman and committee members, my name is Catherine Robb. I'm the National Director of the Children's Justice Campaign. I'm a national expert on statute of limitation reform and other types of child protection legislation. I have testified in over 35 states, written a lot of bills, edited a lot of bills, and I am testifying today in support of SB 589 and 590. I'd just like to share a story. I've been doing this work for, again, over 20 years, but I would like to share a personal story quickly. I'm a mother of 5 children and 1 grandchild recently. 2 years ago, in June of 2023, my oldest son came into my office and he said to me, "Mom, do you remember that time I was really sick and you and Dad took me to the ER when I had a high fever?" And I said, "Yes, I remember." And the doctor told my son's father and me that he was taking him for a test. He was very, very sick. And my son shared with me, through a flood of heavy tears, that the doctor took him to a dark lit place of the hospital in the basement and sodomized him. He was 8 years old, an absolutely perfect little boy. His trauma did not surface until his late 20s. And that was over 20 years ago. So the reason I'm sharing this story is not just that it's personal for me as a national expert and as a mother and as a reasonable woman and as an attorney who believes in due process. I'm sharing this because in the late 1990s, I didn't know that I couldn't trust an ER doctor. And certainly, I didn't know the data then, right? Now, I've been doing this work for 20 years. I didn't know the data on child sexual abuse. I didn't know, the clergy abuse in Spotlight that many of us have seen. I didn't know about Jerry Sandusky and Penn State. I didn't know about Boy Scouts of America or Larry Nassar or the Kanakuk camp. But I say to you that I do know now. We all know now, and you know now. The data indicates that about 1 in 8 children will be sexually assaulted before their 18th birthday. Most predators have hundreds of victims. Victims suffer in silence because of the trauma. The average age a victim comes forward is decades after the abuse. My son would be one example, but there are countless others. It takes until age 50, 60, 70. Sometimes these victims go to their grave with this horrific secret. The cost of this epidemic is staggering. So I just say to everyone here that we know the data now. We understand that this is a silent epidemic, one that affects all children, regardless if their parents are Republicans or Democrats or independents, whether they are black, white, Asian, whether they are Christian, Jewish, Muslim, Buddhist. It is a ubiquitous problem. It is the silent epidemic of our time. I share this also because there's a national trend here where legislative bodies are understanding this data that I just quickly went through. So right now, we have 33 jurisdictions that have passed revival legislation. We have 21 jurisdictions and the federal government that have completely eliminated the statute of limitations. We have several states that are passing what I would call a zero tolerance legislation, which is complete elimination prospectively and a permanent window retrospectively. And basically what lawmakers are saying is we've had enough. We've seen the data, we hear the stories, we watch the news, day after day after day. It's never ending. It's an epidemic. And we are taking a position of zero tolerance on this national epidemic. I want to share that statute of limitation reform serves three really important public policy principles. One is it educates the public on this national epidemic. People need to understand this so they can protect their children. It also, very importantly, shifts the cost of this epidemic, which is enormous. I could share tons of figures on the cost of this. It shifts it away from survivors, victims, their families, and Missouri taxpayers, because they are paying a big part of this bill. And finally, it educates hidden sexual predators. You know, we hear a lot about the money and bringing these claims. I talk to survivors all over the world. Sometimes hundreds a month call me and reach out. One thing I hear again and again and again, almost verbatim from a survivor is, I just don't want this to happen to another child. Not, I want money. That's not what this is about. They see their voice protecting children in the future. And only you can give them that voice, because the power rests with you to change statute of limitations. These are arbitrary, in-house, in-court rules, right? And we're talking about a type of tort or civil wrong that is very different than a slip and fall or a fender bender case or a breach of contract case. We are talking, sadly, about the rape, sodomy, and sexual assault of our children. We should have different rules for that. I just want to touch on, if I may, just a couple of concerns that can come up. You know, we often hear, oh, the courts are going to be flooded. Well, we've looked at data from many, many states, and it is simply not the case. You know, a lot of times we hear, oh, the courts are going to be flooded, and it's really hard for me to prove a negative, right? We just don't see it. Many courts are dealing with this fine. Heavy populated states like California and New York have passed this type of legislation. A very small part of the population have moved forward. The courts have handled it just fine. I believe the judiciary can handle this, and they have in many other states.
While your time has expired, I'll let you a couple seconds just to kind of wrap up.
Sure. So I would just like to address, if I may, quickly what was just the prior testimony by the insurance lobbyist, with all due respect. As to the criminal argument that we have that we have the criminal system to help with this problem, I would just say a couple of things, that the criminal system has limitations. One, we all know it has a higher burden of proof beyond a reasonable doubt. The majority of child sexual assaults do not move forward to prosecution. 9 out of 10 sexual predators will walk free. So it is just not a safe system. It doesn't have the power and the muscle that the civil laws give us. And to just briefly address the issue about insurance, which I think is an important conversation. But, you know, I often think about bad drivers. If you're a bad driver, your premiums are going to go up. If you're a really, really bad driver, you're going to be uninsurable. We should treat institutions and YSOs that deal with children the same way. If you have good, safe practices, procedures, hiring, responses in terms of child protection, you have nothing to worry about. Your premiums are not going to go up. You're not going to deal with, more claims. You don't have to worry about that. I'd also like to point out, Chairman, your point about knowledge of harm. So for all the attorneys in this room, we know that knowledge equals notice, and notice equals duty, and that would trigger a negligence claim. If you know that children are being harmed in your institution, I don't know how else to say this with all due respect, that's negligence, and you're putting children in harm's way. Yes, you should be held accountable, regardless of the insurance issue. Just very quickly, I didn't realize I was going to be testifying on both of these bills at the exact same time. I just want to share that NDAs are not appropriate for child sexual abuse claims. Maybe for a company like Coca-Cola or something like that, right, to hide the ingredients in some sort of product. NDAs shield predators. They cover up, and this is really frightening, prosecutable crimes, felonies against children, and they conceal negligent acts and practices by institutions. They also re-traumatize victims. When we cover up and have secrets, we basically bring these victims right back where they were when they were children. They are silenced, they can't come forward, and therefore children in the future are in danger. Silence protects sexual predators, not our children. With all of that, I am in support, and I hope we can move forward in SB 589 and SB 590, and I'm happy to take any questions, and I thank you for your time.
Yeah, thank you for your time and your testimony today. I'll just wrap up. I know we have a lot of witnesses today. I do think it is a damn shame that parents cannot trust doctors. They can't trust counselors. They can't trust anybody in this day and age, and I absolutely believe there should be some teeth to our laws to stop this from happening. Any questions? Seeing none.
Hi, thank you, Mr. Chairman and committee, for the opportunity to speak before you today in support of SB 589 and 590. My name is Keith Eigert, and I'm a resident of Branson, Missouri, and I have been for over 30 years now. I grew up across the lake from Kanakuk and Branson, the prominent Christian sports camp that's based in my hometown where I still live today. Every summer when I was a kid, all summer long, I could hear the cheers and excitement from Kanakuk echo right across the water into my backyard. Several kids from school went there every year, but it was always a little out of reach financially for my family for me to go myself. However, in 7th grade, I met one of the camp's directors at a local non-denominational youth group, which ended up actually becoming Kanakuk's parachurch ministry called K-Life. This director, named Pete Newman, quickly befriended me and gained my trust, and unbeknownst to me, was starting to groom me. He frequently took me to Kanakuk facilities and events, and it didn't cost a penny. It was a dream come true for me, except for the brainwashing that I was oblivious to, and then the consequential sexual abuse. Long story short, this went on for the rest of my adolescence. And then, one day, without really any warning, Pete basically went MIA. And then a little after that, news articles and coverage started coming out accusing him of grooming children and taking advantage of them. I was stunned and I was severely confused, as I couldn't even make sense of what I was hearing. I had loved, trusted, and respected Pete, so none of these accusations could even fit in my paradigm. Fast forward through months of counseling and only beginning to understand that I was actually a victim, I also inadvertently learned that Joe White, the CEO and owner of Kanakuk Camps to this day, along with other camp leadership, had caught Pete Newman engaging in naked and felonious acts with underage boys. This happened no less than on 3 separate occasions, and at least one of those occasions happened before I even personally met Pete. So just to reemphasize, Kanakuk had caught Pete naked with boys on 3 separate occasions. One of them, at least, happened before I even met Pete. Kanakuk was aware of this. Their leadership was aware of this. The public was not. They did not mandatory report this as they should have. Fast forward several more years, and now I was in a mediation room for a lawsuit against Kanakuk. There are lots of details, but for the sake of time, my honest and true belief, my testimony, is that I had no other option other than to settle with Kanakuk. And that settlement, the only way we could settle, was with the cost of signing an NDA. And that NDA has been a constant warning to myself about how much of my own story I can or cannot tell. My friends in the Alarcon family, they went through a similar lawsuit against Kanakuk, but they absolutely refused to sign an NDA. Kanakuk then sent their lawyers after them for refusing to sign. And then this already traumatized and tired family had to shell out $40,000 simply to defend themselves against a baseless claim. There's another friend of mine who didn't really start getting help processing his trauma until a little later in life. And as you'd have it, the sweet sickness of Kanakuk used its affiliation with my friend's therapist to conveniently dissuade my abused friend from ever considering justice through the legal system against Kanakuk for harboring pedophiles and hiding their abuse. This lasted long enough for this victim to age out of being able to pursue legal justice against Kanakuk. I was exhausted from a years-long legal pursuit. I was hesitant to share my story with my unavoidable NDA. The Alarcons were attacked for refusing to sign away their right to speak. And one of my best friends I grew up with couldn't even seek legal repercussions against the institution that empowered our common childhood sexual abuser. Please tell me which of these scenarios is an example of NDAs or statute of limitations working to protect our children and the public safety. The answer is none of them, and it's actually just the opposite. Kanakuk, who has harbored, protected, and empowered pedophiles and covered up the abuse, has only benefited from truth silencing NDAs and the statute of limitations that prevents more victims from calling to account Kanakuk's crimes. Common sense is a buzzword these days, but making the improvements imposed by SB 589 and 590 has to be just that, common sense. Thank you for letting me share some of my story with you today, and I urge you, I beg you, to see these bills through to law. It's the right thing to do. It's the good thing to do. It is the just thing to do. Thank you.
Thank you for your time and testimony today.
My name's Jody Jones. I'll try and keep this quick. Thank you for your time today and for listening to our stories. I don't mean any disrespect, but I can't believe that we're actually still having this conversation, right? You have a daughter, I heard him say from the beginning, and I'm going to plead to you as my 8-year-old self, who was a camper at Kanakuk camps and was abused by Chuck Price, who admitted the abuse. Nobody called the authorities. They told my mom not to call the authorities, that it would be too hard on me as a child to go through that trial. And I want you to think about your kid or your grandkid or your neighbor. And I want you to think about those children coming to you and telling you about sexual abuse that happened in their life. Would there ever be a time that you would look them in the eye and say, I'm sorry, we can't put that man behind bars because too much time has passed? Time doesn't take away the pain, and it shouldn't ever be a barrier to justice. Keep this really, really sweet and short. But I'm now a 47-year-old woman, and I have the strength to fight on behalf of my 8-year-old self. Do the right thing, please. You have a chance to make this different.
Thank you.
Thanks.
Thank you, Mr. Chairman and members of the committee. My name is Greg Yandell. I'm from Hendersonville, Tennessee. I drove here from Tennessee today because my son signed an NDA. I actually signed it on his behalf while he was a minor. I'm going to leave my testimony here. I want everybody else to have a chance to speak as well. I just want to say two things. As parents, you know you do everything you can for your children. I was personal friends with Joe White when my son went to Kanakuk. We developed that relationship. When my son came forward and told us he was sexually abused, I personally called Joe. Joe lied to me and my family and said, we've never seen anything at Kanakuk, ever. And now we know through investigative reporting that that is an absolute lie. So my son, we ignored the NDA, and my son started going out and telling his story. I almost dared Kanakuk to come after me and the insurance company, by the way, because we had the NDA. But unfortunately, my son's recent fraud case was dismissed due to statute of limitations. And so his voice has been taken away. His opportunity for justice has been taken away because of the statute of limitations. Obviously, we all agree that NDAs should never happen in child abuse cases. My home state, actually in Tennessee, has already approved this. So you cannot use an NDA in child abuse cases in Tennessee. I encourage you to do the same thing here. But I also encourage you to take a look at the statute of limitations and get rid of that. As you hear from testimony after testimony, it takes years. Thank you for your time today.